Welcome everyone to Estate Planning Basics. Today we're going to be looking at kind of an overview of the estate planning process and things that you want to consider planning for and just kind of how the process works in general. Just to remind you, the company putting this on is called Multnomah Group. The relationship we probably have with you and the company you work for is that we consult on your retirement plan, help choose the investment options, make sure that it remains compliant and tax advantaged, all that sort of thing. My name is Tim Slevin-Vegdahl. I'm a financial planner, and I do a combination of educational, things like this, as well as doing individual advice sessions for people who need that. So let's start with the basics. What is an estate plan? So when we're looking at estate planning, we're looking to prepare for what happens to us and our assets when we're no longer able to advocate for ourselves, either because we're incapacitated or dead. So we want to have a plan of action for what happens and have that recorded so that our desires and wishes can be accessed when we're not able to provide what we'd like to happen ourselves. And this can be good for, planning for our legacy. And all of the documents that we'll be talking about are going to be administered by others because we can't do it ourselves if we're incapacitated or dead. So who needs an estate plan? The short answer is everyone needs some degree of an estate plan, but it won't always involve the same things for every stage of life. So different tools will be appropriate for different stages of life and involve different degrees of cost and complexity. So estate plans aren't just for the wealthy. One of the reasons we want to have them in place is a proper estate plan can avoid a lot of big headaches for our family. It can provide family unity during a tough time instead of if it's unclear what is supposed to happen to our estate. Often family fights over those things. If just think about like if you're having trouble figuring out what you want to happen with your assets or who you want to take care of your kids or what to do in the event you're in a vegetative state. If you're having trouble grappling with that yourself, it's extremely unreasonable that you would put that on your family to figure that out when you can't help them figure out what you would have wanted. It helps clarify your desires, and it can potentially preserve assets and provide for people you care about in the way that you'd like it to be done. I'd say you especially need to have some estate planning done if you have a spouse that isn't as comfortable or familiar with financial matters. If you have a significant amount of assets as well, if you have minor children, if you own a business, or if financial privacy is a concern, because kind of the default way that things get handled is a public process. We'll be talking about a bunch of concepts here, planning for incapacity, what the healthcare directives look like, property management, planning for death, a little bit about wills and probates, why you might consider alternatives like trusts, some basics on how taxes work in estate planning, and there's sort of a federal and state level aspect to that. Lifetime gifting, and then why you might consider life insurance as an estate tool as well, although it's really not right for everybody, but is very helpful in some types of estates. As we go through this, everything we talk about is going to be general guidance. We are not attorneys. here at Multnomah Group. Well, I guess we do have one attorney, but they're not an estate planning attorney. So questions are appreciated. Feel free to put them in the Q&A as we go through, especially if you have something that is generally applicable. Those kinds of questions are very much appreciated. So let's start with planning for incapacity. We don't always like to think about it, but incapacity can strike anyone at any time. What's going to happen if you don't have any sort of plan in place is that the courts are going to appoint depending on the situation, either a guardian or executor to handle things for you. A lack of planning really increases the emotional burden on that person, and the decisions they make might not be what you want. So those are all reasons to consider doing this kind of planning ahead of time. So if you're incapacitated, there's several documents that can help people deal with things. There is a living will, which puts your instructions in writing for who can handle various sorts of things for you. Durable power of attorney for healthcare is going to be the person making healthcare decisions on your behalf. And if you are in a later stage of life and you are kind of not wanting certain types of medical care, do not resuscitate orders can let healthcare staff know that you do not want those things to happen to you in the result of a negative health outcome. This is also something that it does vary a bit state by state, so you are going to want to make sure whatever state you're currently living, if you don't have a healthcare directive there, you want to make sure to use the form to fill it out. It'll be the same type of information, but it's just easier if your healthcare staff has access to one that's accepted in the state that you're in. That kind of makes sure that your wishes will be executed effectively and promptly. As far as property management, we have multiple tools for that as well. One is just having joint ownership. This is often done with a spouse. If you jointly own something like a home, then whoever you have joint ownership with is going to have full access to make decisions for that on your behalf. That works really well, especially with spouses. Also, power of attorney for your finances can let someone make decisions for you in terms of any financial accounts that you have. This is especially important with non-spousal people because this will often be assumed for joint assets. But if you are getting to the stage of life where you want kids to be able to make financial decisions for you, definitely something you want to consider. And then having living trust, which we'll talk a little bit more about, but things that are inside some kind of trust can let a successor trustee sort of manage the things that are within the trust on your behalf in the case that you are incapacitated and unable to do so. So what happens if you die without an estate plan? It kind of depends which assets you're talking about. Some things will have designated beneficiaries on them. This is very common with retirement accounts like IRAs and 401ks. That's common with life insurance, that you would just have a beneficiary that things would go directly to. So these things will not necessarily go through the probate process, which we'll talk about in a moment. But if you don't have anything in place, someone will still need to contact those institutions, like whoever your insurer is for a life insurance policy, and kind of get those next steps started. And property that doesn't have any kind of beneficiary designation on it is going to pass according to intestacy laws. What intestacy basically means is that you haven't set up a will, and so instead of your directions guiding what happens to your estate, whatever happened to be the default laws for the state that you die in, not that you die in, that you're a resident in when you die, are going to be what gets executed. So as sometimes is said, you do have an estate plan. It just might not be the one you chose if you haven't gotten one in place, because the state has one for you as a backup. So intestacy laws vary from state to state. Typical distribution divides property between surviving spouse, children, and next of kin in some way. I think being in having no will in place when you die and having assets that need to go through probate causes several problems. It can be a long process. It might not follow your wishes, I think, are kind of the big two. But this can also be where family fights a lot. Like, it's not always clear who should have what, and if your family doesn't kind of align with the default laws that your state has around that, people may contest things a lot, and it could cause real issues for the rest of your family's well-being. So definitely try and avoid that if at all possible, if you have significant assets or if you have children. The document that we use to kind of guide the probate process and avoid intestacy is a will. This is sort of the cornerstone of an estate plan that will direct how assets are to be distributed, as well as naming the person that you'd like to kind of carry out the administrative duties of your estate, called the executor. This can also name who you'd like to be the guardian for your minor children. This doesn't always get followed, but unless there is some major issue, like 99% of the time, if the people that you wanted to handle, or that you wanted to be guardians of your kids when you died, if they are willing to accept that responsibility, there's no like major red flags, they will be the ones who get it. A will has to be written, signed by you, and witnessed. It takes effect after your death and is kind of the instruction manual for the probate court. So it's important for all those assets that don't have a beneficiary designation on them. The probate process is a little bit different state to state, but wills will go through probate court, be presented and filed. They are public record. Then the executor that you appointed, well, not necessarily that you appointed, but assuming that they accept the responsibility, usually that'll be the person you listed that you want to handle your estate. They will go ahead and inventory assets, pay debts and attorney fees, and file final tax returns, and then distribute the rest of the property to heirs. One thing to note is this can be a pretty lengthy process. There's multiple aspects to that. One, though, is the debt process. It varies state to state, but there can be as much as a 6-month period when someone dies for creditors to say, this person owes me some money, like I'm owed something by this estate. So there's often a pretty lengthy period of time for them to make claims against the estate. So this process almost never goes quickly. Kind of depending on the state, I'd say you're looking at like 3 months to a year and a half. So kind of a long process for all your assets to be tied up. And that's one of the reasons we, with some assets, that it's possible to just have beneficiary designations or something that passes more directly. We prefer that. It's just kind of cleaner and quicker. So probate pros and cons. One of the pros is wills are kind of one of the easiest estate documents to get set up to distribute your assets. So the upfront costs are pretty modest. You have court supervision, and this can be important if your family situation changes. One of the most common examples is, say you have a life insurance policy when you die, and you have listed as the beneficiary your ex-spouse that you divorced 2 years ago. There is no protection. Since they're the beneficiary, they will receive that life insurance policy. Whereas if you left them money in your will, then the court will kind of see, hey, it's reasonable to assume that this person who was married at the time they wrote this will, saying they wanted to give everything to this other person, and then they got divorced, they probably didn't really want to give everything to that person. So there's kind of that human supervision over the process. And there's protection against creditors as well. Some cons are probate, like I said, can be very time consuming and just hard for complex estates. Sometimes there are better ways to structure it that'll be easier to administer. There's all kinds of delays. The fees can be expensive. Ancillary probate is an issue where you might have to go through the probate process in multiple states. So if you own any real estate outside the state that you reside, really think about getting that put in a trust because you might be leaving your heirs to go through probate in multiple states if you have real estate outside of the one that you live in. And then finally, everything that happens in this process will be public record. So that's just something to keep in mind as well. Can you avoid probate? I'd say in general, you can't fully avoid it, but you can definitely make almost all of your assets not pass through probate. So an estate plan can be designed using things like joint ownership, trusts, and beneficiary designations to kind of avoid putting most things through probates. So something else that's kind of a tool that we have to avoid probate and simplify things. I already mentioned this with real estate. Trusts are a good tool, and a lot of people don't think of trusts as a thing for everyday people, but there are pretty simple trusts as well as pretty complex trusts. Trusts are basically a versatile estate planning tool that creates a separate entity that can hold property and have a certain way that it treats that property. So the parties involved in a trust are the grantor or truster. This is going to be the person who puts stuff in the trust. The trustees are the people who kind of have control over what the trust does, and it's their job to administer it. And this can be a relative, this can be yourself, this can also be a professional that you pay to be a trustee. And then finally, there's beneficiaries for whom will be benefiting in some way for the trust. One of the most common types of trusts is a revocable living trust. All three of these are the same person. So this is a trust you would put stuff in. You would be the trustee that's deciding how to use things, and you would be the primary beneficiary. And the reason that this is useful is you can select secondary people in the event that you become incapacitated or are dead to be the trustees and beneficiaries. So you get to maintain total control, but sort of have everything in this entity that knows what to do with your assets in the event of your incapacity or death. Some other types of trusts are, or some different aspects of trusts are living trusts that happen while you're living, testamentary trusts that are created often from your will at death. Revocable trusts are trusts that you still have the ability to make changes to them. Irrevocable trusts are where they are a totally separate entity. The person putting money in it kind of, or assets, loses control of them once they're put in there. And these, trusts kind of don't do anything until you fund them. So I think trusts kind of have more upfront costs, but they often can save expense and time later. Again, especially if you have real estate in multiple states, that's really a time you want to think about a trust. So that your executor doesn't have to go through multiple probate processes. That can be a real pain. Another thing we can do to avoid probate or kind of make things go more directly to our heirs is just updating the beneficiaries on accounts. It's also extra important because it won't go through probate and have those protections. So if you might have an ex-spouse or someone that you wouldn't want to receive money as a beneficiary, make sure to go look at those. It's the easiest way to ensure your desires are met. Usually you can do it in 4 or 5 minutes on the website of whoever's custodying the accounts. This supersedes the instructions in your will, avoiding probate. This can also be a tax planning tool if you are charitably inclined. So you can name individuals, but you can also name other organizations. And so pre-tax accounts that you still haven't paid taxes on can go tax-free to charities. So that's an option as well. Types of accounts you can usually do beneficiary designations on are like checkings accounts, savings accounts, retirement accounts, taxable brokerage investment accounts, and you can update either the who to transfer on death or who it's payable on death to. So now we're on to what estate taxes and gift transfer taxes look like. There is a federal gift tax limit that is kind of shared with the estate tax limit. There is an exemption amount per year. You can give to anyone $19,000 a year, and it doesn't affect your federal gift/estate tax limit. But if you give them more than that, it will start eating into that exemption that your estate will have. And then when you die, you will have that much less money that doesn't get taxed by the federal government to go to your heirs. This isn't a huge deal for federal estate taxes, though. In 2026, there is a $15 million per person estate tax exemption. So if you're married, there's essentially $30 million exemption. And so for most people, paying estate taxes isn't actually an issue. This is sort of for the more wealthy side of the spectrum. However, for Oregon and Washington, estate tax thresholds are much lower. And you might want to consider more what you want to do about that if you have an estate that's in Oregon. I think this might be on the next slide or two, but in Oregon, I think the limit is 1 million and maybe 2.5 million in Washington. I did talk about the annual gift tax exclusion, so don't have to file anything if you're only giving $19,000 to someone. If you exceed that amount, you are supposed to file Tax 709 so that the government can keep record of how much of your exemption you've used. This exclusion is unique to each giver and receiver relationship. So you and your spouse can each give $19,000 to one child, resulting in $38,000 with no filing necessary. And likewise, if they have a spouse, each of you can give each of them $19,000, meaning that you could give them up to $76,000 with no filing needed. And you can also just give 19,000 a year to however many people you want. This number is adjusted for inflation, so it will, be a higher number in future years, but it's 19,000 for 2026. And this leads us to, it's kind of a myth that someone must pay taxes on gifts larger than this $19,000 because of the $15 million limit that you have as an exemption for both gifts and estate taxes combined. Rarely do people actually meet that. If you were to gift someone over $15 million and like you've used up that exemption entirely, then you would have to pay 40% tax on that money that you were gifting to people. So the federal estate tax is made on assets upon your death, distributions of assets to your benefits and heirs. It generally does not apply to transferring either to spouses or charities. So there's usually an unlimited exemption for giving to spouses and charities as well. So again, what we're kind of getting at here is very few people does this $15 million per person limit actually result in any estate taxes for. But you do want to make sure that you're doing all the proper forms. You still need to file an estate tax return, which is Form 706. Even if taxes aren't due, you'll still have to file that to kind of show the government that you don't need to file that. As well as kind of the way the $30 million for spouses that I mentioned. If you're giving everything to your spouse, you can generally transfer your exclusion amount to the spouse so that the second to die has the limit of both spouses. Looking at a couple states that have some lower limits, yeah, I was a little bit off here. So in Oregon, there is a $1 million estate tax exemption. In Washington, it's $3 million per person. So a lot of states will have various different estate taxes. Some don't have any at all. Generally, these still don't apply to spouses or charities. The estate value is just going to be all of the other things that you're not giving to a charity or to a spouse, plus half of any joint property that you're transferring not to who the joint owner is. So a couple common states for people would be Oregon, which can have a 10 to 16% tax applied. That's graduated after $1 million. And for Washington, it's 10% all the way up to 39%. But the 39% doesn't hit until very large estate numbers. I don't remember exactly what they are, but I want to say it's like over 100 million or something. Yeah, so one of the things that's interesting though is neither state has a unique gifting threshold from the federal government. So you can actually, on your deathbed, kind of give a bunch of money away to your heirs to avoid this estate tax. And that's something that you may want to take account of in your estate plan if you live in one of those states, because they'll hit the federal gifting limit, but again, that's a limit of $15 million. Much easier to hit a $1 million limit than 15 million. So gifting during your lifetime can be an effective way to kind of limit that estate that you may have to pay taxes on. And there could be a lot of people that you can give $19,000 away to over a number of years, reducing future taxes owed either in Oregon or Washington. Plus, it's just a good thing to consider if you're not planning to spend the money yourself. It can be rewarding to give money to family and see them get to benefit from it, as well as giving to charities. I know that my mom became the trustee of a charitable trust that my grandfather had set up. And she's really enjoyed getting to gift that money to charities, and interacting with them while they're getting these larger gifts. Yeah, it can be very rewarding to get to see people and organizations benefit from the gifts that you're giving them. Also, yeah, continuing to take advantage of that $19,000 per person limit. Transfers, there's a couple kind of transfers that are kind of exempted from this limit as well. So if you're directly paying money to a school or a hospital for either education or medical care for someone else, these are not counted towards the $19,000 a year limit. Another thing is if you're doing college planning, you are allowed to kind of bunch years, making 529 contributions and make a 5-year worth of gift exclusions at once, so up to $95,000. Another thing to note, at least with the way estate law currently works, you do get a step up in basis for things that are given to heirs. So when you are paying taxes on appreciated assets, if you were to sell them, you pay taxes on the difference between the basis technically, but usually what you bought it for, and then what you sold it for. That's sort of the gain that you have and have to pay taxes on. When you die, your heirs will inherit it as if they had bought it at the price on the date of your death, and no one has to pay taxes on the difference. So this is something to consider when gifting assets. Assets that have a lot of appreciation tend to be better to hold, to pass on when you die, as compared to assets that don't have a lot of appreciation. Those tend to be good for gifting. Like cash is probably the most easy example. One final thing we want to talk about here before we wrap up is how insurance can help protect your family and estate. So life insurance is a very good tool for insuring against a couple types of things. One is your income loss in the event of your death while your family is expecting a long stream of income from your working life. That is kind of where we prefer term life. It's the cheapest way to get the coverage you need to protect your family. But there's also other types of life insurance like whole life and universal life. These are more permanent types of policies, and they're good for providing estate liquidity. You don't tend to get much coverage in a sense for the money that you put in with whole and universal life. But they're good for covering things like paying estate taxes, making sure your estate has liquidity to maintain properties while it goes through probate. Or sometimes you might be passing on like a business or something. So just anytime your estate would need money to pay taxes or maintain something else, it's nice to have that money that appears that coincides with your death for that purpose. It's easy to make adjustments to these policies. You usually just talk to an insurance broker. The term life is cheaper, and that's why we like it for an actual current insurable need. But the more permanent policies like whole life and universal, they'll be more expensive. They have this cash value component. But we like them for planning for estate liquidity because term life expires and whole or universal life kind of sticks around until you die and provides the liquidity at the right time. These policies also, especially with universal life, can have an index component where it allows for investing. But it's important when using insurance products to understand, especially the costs involved. They can usually be quite high. So if actually investing and growing your money is the goal, life insurance is usually not the most appropriate vehicle for doing that. And as we're wrapping up here, just to kind of summarize, kind of think about what is your current plan for your assets, how you would want things to happen in the event of your incapacity or your passing. Do you have a valid will? Do you have reasons to be concerned about estate taxes? Either you have a very large estate or a more modest one, but you live in Oregon and Washington. And does your overall estate plan reflect your current wishes and circumstances? So give some intentional thought. The first step is kind of understanding what you'd like to happen to your assets and who you'd like to take care of your kids in the event of your death, if you have minor children. And then kind of reviewing the ownership structure of things, reviewing beneficiary designations on accounts, and then finally meeting with a professional, usually to get estate documents drafted. There are online ways to do this, but I'd say once you have any substantial assets, I would go through an attorney for getting your will and trust, if required, set up. But yeah, the online resources are an option for kind of more simple estate plans if you just need something really simple and to get it in place quickly. And then review insurance policies and make sure that you're properly insured. As you have more kids or more obligations, you'll probably want a higher degree of life insurance. And then as you approach more retirement age here, you probably will have quite a bit less need for insurance. And I had mentioned permanent policies are good for providing estate liquidity. I think most estates don't actually require that. It's kind of if you have a more complex estate that will become an issue. But if that's you, definitely think about reaching out to a professional to get some help with that as well. All right, that's all we've got for the presentation today. I will stick, oh, it looks like there was probably some questions in the chat as far instead of in the Q&A. Sorry about missing that for so long. I will go back and look. Does a durable power of attorney naturally cover both health and finances, or does it need distinguishing? It can be either. You can get a general power of attorney that covers both, but you can also have a separate power of attorney for one or the other. Depending on your circumstances, you may want a different person to be handling each, health or financial issues, or you may want it to be the same people for both. So those can both be the case. Thanks for the question. All right, if there's not anything else, then that's all I've got for you guys today. You have a great day.